wants to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning, three cases this morning. First is 2345, Pohl versus Cheatham from Harris County in the First Court of Appeals District. Justice Devine is not participating in the decision of that case. Then 23365, EIS Development 2 versus Buena Vista Area Association from Ellis County and the 8th Court of Appeals District. And finally, 24116, Port Arthur Community Action Network versus the Texas Commission on Environmental Quality, certified question from the United States Court of Appeals for the Fifth Circuit. The court has allotted 20 minutes for each side in each of the cases, and we'll take a brief recess in between the arguments, concluding them before the lunch break. Justice Busby expects to participate in the decision of all cases, but cannot be present until later. The arguments are being broadcast, webcast live this morning, and will be available in the court's archives at a later time. We'll hear argument in 2345.
May it please the court, Mr. Phillips and Mr. Gagey will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Mr. Phillips will open with the first 10 minutes, and Mr. Gagey will present the next 5 minutes in rebuttal.
May it please the court. In my time here this morning, I would like to make 3 arguments about extraterritoriality. The first is that you cannot resolve this case without addressing the issue of extraterritoriality, and the Court of Appeals erred in attempting to avoid it. The second is, once you do address it, the plaintiffs cannot overcome the presumption against extraterritoriality in this case for a host of reasons. And the third is that the presumption against extraterritoriality should be maintained by this court for the reasons it has articulated in the past, and also because it is a useful application of the presumption against reaching a constitutional issue that can be avoided. The Court of Appeals said it did not need to decide extraterritoriality because the focus of the respondent's suit was on the acts that the attorneys and Donaldo Pohl committed, if they committed any at all, in Texas. This reasoning ignores the structure of Section 82.0561. Subsection A, on which this suit is brought, requires that the plaintiffs have entered into contracts procured as a result of conduct violating one of 2 sections of the Penal Code of Texas, or a disciplinary rule. Since the people who did the soliciting were not attorneys, only the 2 criminal sections may apply to them. Really only the first section applies to them. And that conduct happened out of state. It happened in Louisiana and Arkansas. So the plaintiffs can only meet the threshold of this case if they prove that they were victims of a solicitation that, had it occurred in Texas, would have violated Texas law. That's an extraterritorial application of Texas law. Respondents and the court below said they didn't need to examine this because subsection E required the statute to be liberally construed to promote its underlying purposes. And there were several sub-reasons for that. First is that the statute had to be as broad as the criminal laws against solicitation and as the disciplinary rule, or else it would not be liberally applied. I look at this as sort of an ontological proof of scope. Texas law does not support that. In Texas Law Shield versus Crowley, an opinion authored by Justice Busby, the 14th Court reversed a class certification based on Section 82.0651 because it said that there was too much dissimilarity in the facts. because you had to look not just at the conduct of the lawyer, but the conduct of the person hired to solicit for the lawyer. The court's opinion says, liberal construction does not authorize a court to disregard a statute's plain language. And the plain language of this statute makes the Civil Barratry Act more limited in scope than either the disciplinary rule or the penal code. Beyond that, subsection E clearly expresses the statute's purposes. And those purposes are to protect those in need of legal services against unethical, unlawful solicitation, and to provide efficient and economical procedures to secure that protection. Thus, by the very terms of the statute, its focus is on solicitation and not on what an attorney in another state from that solicitation may or may not have done to encourage it. Finally, the Court of Appeals said it could avoid extraterritoriality because the Civil Barratry Statute was premised on a violation of either of the subsections of the Penal Code. And the extraterritorial reach of Penal Code Section 104 presumptively applies to any civil statute that refers to any section of the Penal Code. Now, that was a plausible argument until last May when this court decided the case of Goldstein versus Sabatino, which was exactly the same situation. There was a civil statute, that one for seeking a protective order against conduct. Well, I'm blanking on the word, but anyway, when you're trying to harass somebody that you've been in a relationship with.
Stalking.
Good enough. Stalking. Anyway, that was a penal code. It was in the penal code, but it was a civil statute that allowed for a protective order. But all the conduct of which the plaintiff was complaining occurred in Massachusetts. And this court unanimously held that Penal Code Section 104 was there for a specific purpose, and that was to prove the jurisdictional aspect of a criminal prosecution and had no application in a civil case. So,
What do we do when part of the conduct did occur here? So in Sabatino, all of the conduct, all of the stalking events complained of happened in Massachusetts. And here we have, at least if you focus on subsection B, the penal code prohibits financing. That's the conduct that is alleged to have occurred here.
And I think you have to look at the plain language of the statute. You have to look at subsection E, which says that the purposes of this act are to prevent a potential client from being subjected to unlawful solicitation. The respondents want you to look at a snippet of legislative history written by a legislative staffer, and they want you to look at a report from the Grievance Oversight Committee that said Texas had broader civil protections than any other state in the union against solicitation. Well, of course that's true. As you can see from tab E in our bench book, it's the only state that has I think actually it's tab F. We're the only state in the union that has a civil statute awarding damages for someone who has been unlawfully solicited. So to say that the purpose was primarily to punish lawyers is to ignore what the legislature itself said, both in the original statute and when it was amended in 2013. And since the presumption against extraterritoriality applies unless the legislature has clearly indicated that it wants a statute to apply out of state, I don't see how you can take that purpose statement and say, well, the legislature really wanted to use this to get maximum number of $10,000 fines and attorney's fees shifting against attorneys in Texas, but they just didn't say it.
But I don't think that's what's. No,
Go ahead. I was going to say, I wasn't talking about legislative history so much as the text of 3812 subsection B, which makes it an offense to sub 1 knowingly finance a commission of an offense under A,
Right.
or under sub 3, accept the employment within the scope of the license.
And that's where my question is going, and it's that, I mean, I'm not seeing where it has to be that everything was, dealt with here in Texas, but just some of it.
Well, as Justice Scalia said, it would be a craven watchdog indeed that retreated to its kennel whenever there was any domestic application of the statute that was involved. The federal courts look now to the focus of the statute. And here, subsection E says the focus is solicitation. Then they look to where the conduct occurred related to that focus. And the court's done that in its last two big opinions, RJR Nabisco in 2016 and then in Abatron in 2023. So if you look at the focus and you take the legislature at its word, it's solicitation. And then you look at where that conduct occurred, and it happened in Louisiana and Arkansas and did not happen in Texas.
If the same things had happened here, except that those who were solicited were Texans who happened to be visiting Louisiana and Arkansas during the time of the solicitation, would your argument be the same?
It would perhaps be a closer case
But
if
why?
they were here. I still think it's the same because the lawsuits weren't, there's very little contact here in Texas. I mean, these lawsuits were not brought in Texas. These people did not reside in Texas. Settlement wasn't made. They didn't make their recovery in Texas.
Well, which one of those is necessary in order for it not to be extraterritorial?
Well, I think you have to look at where the solicitation is. If you're going to apply this presumption against extraterritoriality, you have to look at that solicitation and where it happened. And if it happened there, this Texas law can penalize these lawyers. It can criminally fine them or or imprison them. Their law license can be suspended or taken away. But this statute does not pile onto that and say Texas has decided that whatever your state might think, wherever you were solicited, and where
Yeah, but in my hypothetical, your state is Texas. They just happen to be in Louisiana.
well, it's a
or
closer
Arkansas.
case, and I don't know if you'd want to fiddle with that presumption against extraterritoriality or not. The presumption serves a very useful purpose because, as I've only got 12 seconds, as Professor Laycock said in a law review, 92 Columbia 249, there are many ways that a state extraterritorial statute can violate the Constitution. Full faith and credit privileges and immunities, comity, federalism, or state equality.
If this
or
case-
dormant commerce clause or due process.
Which of those would be risked if the statute clearly, so suppose there's no presumption anymore, we have an express statement in the statute. Which constitutional problem is it that statute, as redrafted, would implicate?
I'm not sure any of the language provisions like due process, we'd certainly be looking at that. Whether we could overcome them or not, I don't know.
I mean, to
But I
avoid
do
a
think,
constitutional problem,
Yes.
there has to be some constitutional problem. What is it?
well, the Supreme Court has talked about general concepts of federalism and state sovereignty. And they talked about that in BMW versus Gore, quoted the old Bonaparte case from 1881, that no state can decide policy for another state. So in some states, for instance in Arkansas, there's no prohibition against a lawyer going out and getting somebody to solicit for them. The solicitor is in trouble. And there's certainly no civil recovery. There's no statute other than in Texas. There may be some states that haven't thought about this issue in a long time that would allow a common law remedy.
So I would agree, surely, that there's a potential problem if the Texas statute were to reach an Arkansas lawyer committing what we would regard as barratry in Arkansas for an Arkansas resident. But what's the problem if Texas, which has jurisdiction over all Texas lawyers, were to say, we don't want, as a matter of regulation of our bar, this conduct to happen regardless of where the actual solicitation is made?
If Section E of this statute said, the reason for this statute is that we don't think our criminal laws or lawyer disciplinary system are strong enough to shut barratry down. Our history has proven that. And so therefore, if a Texas lawyer has anything to do with solicitation anywhere in the world, the solicited client or potential client can get fees, cannot pay any of their fees, can get fee shifting for the lawsuit and a $10,000 fine. That would be a much harder case. We'd be looking at this list of constitutional issues and seeing, is there any way this is wrong? But that's not what this statute says. And Texas has had this presumption for almost 150 years. Most states still have the presumption. And when you apply that and look at this language, you say it's okay for a civil statute to be narrower in scope than other statutes trying other methods to discourage the same conduct.
And just briefly, do I understand you're relying on your briefs, you're resting on your briefs as to the res judicata point?
Yes, I would answer questions, but since that only resolves half the case, we'd rather spend our time on an outcome dispositive issue. And I'm sorry that I took 3.5 minutes of my co-counsel's time.
It was not entirely your fault. Yeah.
Not entirely. They have other issues that Petitioner Ammons does not present.
I think
Chief.
there's another question.
Thank you, Chief. Just briefly, what are your thoughts on the Salesforce case that we had a letter about just yesterday?
Well, I think it's distinguishable and wrong. So first, it's wrong because
The
the
case
judge...
is wrong or the letter is wrong?
Well, the letter's only wrong because it says this is a case you should follow. First, it relies on liberal construction, and I'm sorry you missed my bragging on your Texas Shield opinion about liberal construction. There's also law reviews.
Well, I want to apologize to you and to the council and the parties. I was summoned to testify over in the legislature this morning, so I apologize for being tardy, and I will review the rest of it online.
The separation of powers has its limits. Secondly, it relies on Section 104 in exactly the way Goldstein versus Sabatino says not to do. And third, and most important, it reverses the presumption. It says that it has not clearly been shown that the legislature did not intend for this to apply extraterritorially. It relies on the facts of Marmon, does not rely on its holding or on Coca-Cola or any other case, Maximus, where this court has stated that you've got to overcome the presumption if you want it to apply extraterritorially, not the other way. Now, it's distinguishable because, as in Docock, this case, the stalking, prostitution and the taking of minors and trafficking them across state lines, that is a civil crime in a majority of the states, and there is a federal crime as well, and there is a model statute. So this is really a choice of law problem, like the dissenters would have made the Coca-Cola case to be. So you're talking about somebody in Oklahoma or whatever state this occurred in. Should you apply their version of the civil statute, or should you apply the Texas version? Here, nobody's arguing to apply a Louisiana or Arkansas statute because there isn't one, and there's no evidence that there's a common law recovery. In Louisiana, there clearly is not. So this is a extraterritoriality as a threshold question matter.
Any other questions? Thank you, Mr. Phillips. Mr. Gagey, we'll hear from you.
May it please the court, in addition to the arguments presented by Mr. Phillips about the extraterritoriality issue, there's an independent basis for the affirmance of the motion for summary judgment as to my clients. This lawsuit was brought too late because the 2-year statute of limitations applies instead of the 4-year statute of limitations. The first court has improperly split the civil barratry statute into two. It has applied a 4-year statute of limitations to subsection A and a 2-year statute of limitations to subsection C. But this court has never endorsed a limitations analysis where the nature of the injury is the same and there's just a difference in the identity of the claimant. In the area of limitations, this court has repeatedly emphasized the need for categorical and bright line rules because they ensure predictability and consistency in the jurisprudence. But the first court's holding will create confusion. Consider the following hypothetical. 2 siblings are improperly solicited by a middleman. One signs a contract, the other does not sign a contract. The very next day, the lawyer voluntarily voids the contract, so no fees have changed hands. Under the first court's logic, these similarly situated claimants now have 2 different statute of limitations. One has 4 years to file suit, and one has 2 years to file suit. This was the error at the heart of the first court's analysis. Now, this court usually looks to analogous causes of action when there is no express statute of limitations. And the question it asks is whether the cause of action sounds in tort or in contract. And so you look to the source of the duty imposed and the nature of the remedy sought. And both those factors point towards tort in this case. I'd invite the court to flip to tab K, which is the statute at issue. Now, obviously, the source of the duty imposed is the same for subsection A and for subsection C. It's the 2011 statute that was amended in 2013. And this court has told us that breach of a duty created by a contract gives rise to a contract claim, but breach of a duty imposed by the operation of law gives rise to a tort claim. This duty is being imposed by law, not by contract.
In your hypo, at least, though, one of the siblings entered into a contract. It may well be that it was voided, and it's possible that the duty didn't fully arise just from the contract, but the claim is based on that contract that should not have been entered into under those circumstances. Why isn't that a distinction?
Your Honor, there are two responses to that. First, the duty is not arising because the contract exists. The duty is arising because of the operation of this statute. And second, it's not like a traditional breach of contract claim as you would conceive of it. In a breach of contract claim, the essence is that we had a contract and you didn't perform on it. But in a claim under this statute, essentially what they're complaining about is you shouldn't have been my lawyer in the first place. They're complaining about performance of the contract. And indeed, these claimants, had a representation and there were successful settlements for both. And so it's not like a contract claim in that sense in terms of the duty. And then I'd also point to the remedies that are in this statute. If you look at subsection B, number 1 and 2, what the first court said is this is essentially like a rescission-like remedy.
Do we have to put it in one box or the other? And if it resists that categorization, then what's the statute of limitations?
Your Honor, I think you do have to put it in one box or the other because this court has said reasoning by analogy is the way to find what the proper statute of limitations is. And
the legislature can create all kinds of causes of action that have nothing to do with the common law and don't necessarily map onto the way we traditionally think about torts and contracts. So do we we're forced to categorize the legislature's hand-tailored causes of action as either tort or contract?
Your Honor, based on this court's precedent in cases like Negham and in Johnson, you have to first apply analogies. And so the closest analogy here is to a tort or to trespass, because this tort is really about the dignity of citizens to be free from solicitation for legal employment.
Isn't it a little more like there are duties that are imposed by law in the context of, when you've got situations like we've had in some of our recent cases about, warranties and things like that are imposed by law but also involve a contract. So why isn't this more like that situation, especially given that the principal remedy appears to be rescission?
Well, Your Honor, I see that my time is almost up.
You may respond.
Well, the answer to that, Your Honor, is in the implied warranty context. If you didn't have the contract, you would not have a cause of action for implied warranty.
Well, you wouldn't have a cause of action for most people here either, right? If you're trying to under A.
Well, Your Honor, I think what you need to do is take a step back and say, well, even if there is not a contract, this statute does give you a cause of action. It just
A
be under.
does?
Well, no, but subsection C does.
So why isn't that a basis for distinguishing between A and C?
Well, because they both originate from the same statute. And so what you would be.
So if A had been 820651 and C had been 820652, your argument would be different?
Maybe it would be, but Your Honor, in that case too.
Why can't we just do what Justice Blacklock said? And if we have to, if it resists categorization, fine, but if there's a way to split them up, why shouldn't we split them up and try to match them the best we can?
Well, because you have repeatedly told us, look at the source of the duty imposed, look at the nature of the remedies. You said just now that there's a rescission-like remedy, but rescission requires mutual restoration and accounting. That's what this court has repeatedly held. There's no mutual restoration in this statute. The client gets all the fees back, and the only person who gets quantum merit in this statute is the innocent lawyer, not someone who's liable under the statute. So this is not a rescission-like remedy. And then second, the actual
statute of limitations should be known in advance, or else it's difficult to justify taking someone's claim away based on a statute of limitations that really can't be known until you go in front of a court and ask it to decide whether this is more like a tort or more like a contract. And I think we can all agree that this is, this is amenable to multiple viewpoints on that score. It's a complicated statute that was not written with an eye towards it being a tort claim or a contract claim. So my point is, if we're going to do this analysis after the fact, and it's going to turn on to these finer points, well, is it more like a tort claim or a contract claim, and who knows, and what does the judge think? People aren't going to know beforehand.
Well, Your Honor, if we were writing on a blank slate, maybe that would be the way we would do limitations analysis, but we're not. We have a history of doing analogy and looking at whether it sounds in tort or contract, and not just this court, but lower appellate courts as well. And I think what you were hinting at there is the residual limitation statute, but that's been on the books since at least 1879, and in all that time, the Texas courts have been doing reasoning by analogy. And so there are 2 points to be made here. First, the legislature, when it passed the statute, is presumed to know that that's how limitations analysis works. You do it by analogy, and that's what it was relying on in passing the statute. And second, just last year, this court said that stare decisis is at its greatest force when the legislature could fix a problem or an issue, but it does not. And so if the legislature wanted to prevent reasoning by analogy, it could amend the statute and say, well, please don't reason by analogy. If it isn't expressed, then you have to use the residual statute of limitations, but it hasn't done that.
But you don't want us to use the residual statute of limitations.
That's right, Your Honor, because this court's precedent says, look at, does it sound in contract or does it sound in tort, and reason by that way.
What if we think it sounds more like fraud?
Well, Your Honor, the response to that is a fraud requires a misrepresentation of some kind. You say X and actually that's not true.
I'm saying that it is fraud.
Right.
I'm saying that it sounds more like it. This is the analogies. What if we come to that conclusion? What
Well,
would the result
I
be?
mean, that was what my response is going to be. I mean, the issue here is not someone went to these claimants and said, I am a lawyer, and it turns out they're not a lawyer. The issue is they're actually a lawyer, they signed up the case, they did exactly what they promised to do, which is successfully prosecute the case and get a settlement. And so analogy to fraud would be inappropriate in this circumstance.
But if we reach that conclusion nonetheless, what would the answer as to limitations be?
If you analogize to fraud, then fraud is obviously governed by a 4-year statute of limitations.
And if we think it's in equipoise, this I took to be one of Justice Blacklock's questions. I don't think I got an answer that I heard from you. If we do the analogy and we just cannot come up with more than a 50% for one, 50% the other, what then?
Well, in that case, if you cannot do the analogy in terms of contract or tort, what I would say is you have to look at similar causes of action, and the most similar cause of action here is trespass itself.
The residual statute of limitations just doesn't do very much.
Not based on this court's precedent and the fact that the legislature knows about it.
Other questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Kassab will present argument for the respondent.
May it please the court. 82.0651 was enacted as a mechanism of civil enforcement to deter barratry and hold those who commit it accountable civilly. Petitioners do not want this court to hold them accountable. They want to avoid civil responsibility based upon an unreasonable construction of the statute. To be clear, there is no dispute that the conduct giving rise to the claims in this case, the financing and the directing of the unlawful solicitation, is both criminally punishable under 38.12 and the lawyer would be held professionally liable under Rule 7.03, even if the solicitation was to occur across state lines. But petitioners want this court to hold that this civil mechanism of enforcement of those statutes simply does not apply.
If all of the conduct had taken place in Florida, let's say, would you have a claim?
We would have a claim because I think the same result would occur. And the reason being is because the rule of professional conduct 7.03 applies even if the conduct committed by the lawyer occurs out of state. And what the jurisdictional rule 8.05 says is that if a lawyer commits professional misconduct out of state, that would be professional misconduct inside the state, then the lawyer still commits the act of barratry. And if the lawyer commits the act of barratry, he is within the class of persons that the civil statute was designed to hold accountable.
The civil statute is concerned with violations of the penal code, right?
And Rule 7.03. It says that a client whose contract is procured by conduct violating 38.12A or B of the penal code or Rule 7.03 has a claim, a right of action occurs. And even if we're looking at only the penal code itself has the jurisdictional rule 1.04, which would extend the jurisdiction and hold the lawyer in that situation accountable.
What if you have a law license in Texas and Florida and the conduct's not illegal in Florida?
Still, under our interpretation, the lawyer would be committing barratry because it would be barratry as defined by the laws of this state, and they are not able to commit barratry outside of Texas if that conduct is professional misconduct in Texas.
What if a lawyer is named the lead lawyer in an MDL or a class action, a Texas lawyer, and there are clients that were part of the class or part of the MDL that were solicited lawfully in the states where they reside? Still barratry if the lawyer participates in representing those clients?
And I have to get clarification, Your Honor. Does the lawyer know that the clients were procured by barratry? Because that's a prerequisite to them committing barratry themselves, which would then give rise to liability.
Right. Say the lawyer knows that other lawyers in other states lawfully solicited clients, and they become part of an MDL, and the Texas lawyer becomes part of the coordinating counsel for pretrial matters, or becomes part of the lead lawyer in a class action.
And that lawyer accepts the employment outside of the state of Texas?
Inside or outside, say. I'm just trying to figure out, does a lawyer violate the barratry statute by undertaking that kind of representation where everything was lawful somewhere else,
Right.
but not in Texas?
I think that the inquiry is whether or not that conduct would be barratry within the penal code 38.12A or B, or professional misconduct constituting barratry under Rule 7.03. And if so,
I think you're arguing that it is, though, and that seems a little bit unworkable given that more than half the cases in federal court these days are MDLs.
and I understand, I think it would be a little bit harder under the penal code because territorial jurisdiction only applies if, part of the conduct occurs out of state, but other conduct occurs in state. And I don't think we need to go down that trail because here it's undisputed that the predicate conduct giving rise to the liability of petitioners all occurred in the state of Texas. And what I mean by predicate acts of liability is we're not suing, petitioners have not been sued for the unlawful solicitation. They have been sued for the financing and the directing of the unlawful solicitation.
But if it's not unlawful, then what are they financing?
Exactly. If it is not unlawful solicitation under an analogy, then I agree that the statute would not apply. But here, it is unlawful.
Why does Texas law determine that question if the solicitation itself actually happened elsewhere?
Because the statute provides that if somebody commits barratry under Texas law in violation of the penal code, then that person is somebody who commits barratry that is liable to the claimant whose contract was procured by conduct constituting barratry.
I feel like we're kind of chasing each other around here. It seems like you have to at some point have a stopped point where we can say the thing that actually happened was unlawful where it happened. And I don't see how it can simultaneously be lawful and unlawful in order to trigger that, the financing aspect of it.
I think that if we look at what was the legislator's intent in enacting the civil statute, the legislator wanted to hold those who commit unlawful barratry in violation of the penal code accountable and those who commit professional
Well, if they
misconduct
wanted to
accountable.
do that, given the presumption against extraterritoriality, wouldn't we expect them to be a heck of a lot clearer about that?
I don't think they needed to be clearer because I think it's presumed that if somebody commits barratry in violation of that law.
Yeah, but again, you're assuming the very premise here. Is it barratry if where it happened, it was okay?
Even absent language, Your Honor, I think you can look to the history and the purpose of the statute.
I mean, when you say, look to legislative intent, look to history, look to purpose, that's all well and good, but those are not strong arguments when we have a strong presumption against extraterritoriality, where we usually expect something more than history, purpose, what were they hoping to achieve. We want text so that people will actually understand without any shadow of a doubt what they can do and what they can't do and where.
I understand, and the court in Citizen Insurance looked to the statute in order, and even absent express language that it would apply to out-of-state conduct, held that it applied to out-of-state injuries regarding the registration requirements of somebody who's selling securities has to register in the state of Texas. And the court held in Citizens Insurance that even absent the language, express language of extraterritoriality, that statute applied to sales to out-of-state residents based on its purpose.
Just to take an extreme example, because it doesn't seem like you want to give any ground at all on even the possibility that there could be, that extraterritoriality could ever be a factor. I mean, if somebody in Singapore there's a business deal involving, everybody's in Asia and everything's happening in Asia, and it violates the Texas barratry statute, but they've got a completely different legal system, and everybody knows that none of this applies. Does it make any sense to say that person has violated the Texas Penal Code?
Not the penal code, because none of the conduct was committed inside of Texas. But I think that with regard to Rule 7.03, if that lawyer is engaging in conduct that would give rise to professional discipline.
They're licensed in Singapore to do Singapore law and do everything over there, and they do something that clearly is if it happened in Texas, would violate the disciplinary rule and the penal code, but it's happening in Singapore. Is it correct in any conceivable sense to say that they violated Texas law?
Under the construction of the statute, which simply says that if somebody commits barratry in violation of 703, they become liable. That's the legislator's intent, to hold Texas lawyers accountable.
If they commit it in violation of this, and my point is, if you're completely outside the jurisdiction, does it make any sense to say that you violated that jurisdiction's law?
If they were outside of the jurisdiction, no. But here.
So this just comes down to a factual question of how much of this took place within the jurisdiction and whether that's enough?
I think it comes down to the question of what gives rise to their liability. What would make them criminally responsible for the barratry? And these folks would not be able to be prosecuted for the violation of the penal code governing in-person solicitation because they were not the ones in-person soliciting. They would be prosecuted for the financing and the directing of the solicitation, and that all that predicate conduct, it's undisputed, occurred in Texas.
If you solicit someone, hire someone to commit murder in Tennessee, and they succeed, are you prosecuted for solicitation of murder in Texas or solicitation of murder in Tennessee?
I believe the extraterritorial jurisdiction the territorial jurisdiction statute of the Criminal Penal Code 1.04 would allow the prosecution to take place here in Texas.
What if the murder were allowed in Tennessee, though?
I think you may have it may have raised constitutional concerns.
And so that's the question here is if the thing that actually ended up happening in Louisiana and Arkansas was not a problem in Louisiana or Arkansas, if there's a constitutional problem in that hypothetical, then I think that only doubles the concern about the presumption against extraterritoriality, doesn't it?
In Citizens Insurance, the court rejected a similar federalism type argument. And they said that applying the statute to sales out of state was not a question of federalism, and it did no harm to the individuals who had the claims brought against them because they were Texas sellers and they were obligated under Texas law to register. And the same is true here with Texas lawyers who are obligated to follow the Texas rules of professional conduct and the Texas law governing barratry. So it does no harm to hold them accountable. This court said in O'Quinn, it's O'Quinn decision, that the state has the obligation to regulate the conduct of its lawyers. And that was the direct purpose of this statute. The legislator believed that this court's grievance oversight committee, for instance, in a 2012 report noted that barratry had been running rampant despite the criminal law being on the books for over 100 years. And the legislator recognized that. And so they held expressly in the bill analysis, quote, adding a civil enforcement option would help curtail this practice. That's what they wanted to do. In their 2013 bill analysis, when they amended the statute, and that amendment was simply to add a civil penalty for somebody who entered into a contract. The original statute provided you can rescind the contract, but you don't get a civil penalty. And so there was a loophole that the legislator was trying to close to, again, quote, hold attorneys who commit barratry accountable for their actions. That is what they wanted to do. And it makes absolutely no sense to apply the statute, to not apply the civil statute in a situation like this, because you would have the plaintiff be the class of persons that the legislator intended to protect as a victim of barratry. You would have the defendant as the class of persons the legislator intended to hold accountable as somebody who committed barratry and procured a contract in violation of the barratry laws. And they could even be held criminally liable and convicted of that. But yet, if the solicitation occurred out of state, no civil liability. And that is just not a proper construction of the civil statute. That does not hold lawyers accountable for their actions. That tells every Texas lawyer that they can commit barratry emanating from Texas as long as they target the solicitation across state lines in Texarkana, Arkansas, and not Texarkana, Texas.
But do you need to go that far if your position is that the financing itself was unlawful and the financing took place in Texas?
Exactly. I don't think we even get to an extraterritoriality issue, which is why I think the Court of Appeals was correct in its decision, because all of the predicate conduct that gives rise to these folks' liability occurred in Texas. It may be different if the person who did the soliciting was involved in this lawsuit, but they are not. And so I don't think you even get to that analysis. But if you do, we think that the statute was intended to apply to out-of-state, just like the court in Salesforce held.
And would that analysis and conclusion be the same if you were here representing the Commission on Lawyer Discipline, wanting to discipline a Texas lawyer for out-of-state conduct that violates a Texas disciplinary rule but not a disciplinary rule in that state? Would your analysis and conclusion be the same? Or is your analysis and conclusion here uniquely dependent on 820651 and 3812, the statutes you're relying on?
Yeah, the analysis would be the same, because the jurisdictional component of the disciplinary rules 8.05 provides that if you commit conduct in this state or even out of this state, that would constitute conduct for which you could be disciplined in this state, then the bar would have jurisdiction to hold that lawyer professionally accountable.
The Louisiana court seemed to tell us that there was no problem at all in what happened there.
Are you talking, Justice, about the judgment that was obtained by Mr. Ammons in the concursus proceeding? I think the court came to that conclusion because simply Mr. Cheatham withdrew any opposition to that, relying on the statements by Mr. Ammons' counsel that the barratry action was here and the fee dispute was in Louisiana, and the two proceedings were different and not the same.
But I thought that the Louisiana court went a little further than that and expressly didn't just say, oh, well, the case is withdrawn, don't need to do anything more with that. It sort of went to the trouble of saying what occurred here, and the basis for allowing the fees to be paid is that there were no improprieties.
Sure, with no opposition, I think that an order was submitted and it was signed. I think that the court came to its conclusion based on what was before it, with the objection by Cheatham having been withdrawn because the issues of barratry were up here. And that kind of gets into the res judicata argument. I know that Mr. Ammons' counsel didn't mention it. We will stand on our briefs regarding that. The only thing that I would add to that is this court recently decided the Fleming case. And in the Fleming case, it held that judicial estoppel applied to very similar type conduct by a lawyer who once claimed initially that the proceedings were different to avoid class certification, and then turned around after he won a bellwether trial in a group of plaintiffs who were suing him and said, no, they're the same, so grant summary judgment based on collateral estoppel. And this court reversed that, stating that.
But here the positions seem to be consistent. I didn't commit barratry in Texas. I didn't commit barratry. Those are the arguments in both cases.
Sure,
So I'm not seeing the inconsistent legal positions.
That position is consistent. The inconsistent position is Mr. Ammons' counsel told the Texas trial court that the issues of barratry are here, and we're going to be litigating the barratry case over here. And then he went down to, he said that the fee claim was involved in the Louisiana case. And so then after he got the judgment in the Louisiana case, he then used the judgment in the Louisiana case to come back here to the Texas court, the barratry case, and state, okay, the claim is barred because it's conclusively barred by the judgment that was obtained in Louisiana.
So what was the success that was obtained in the first court, in the Texas court? That would be the predicate for judicial estoppel, which I would assume would actually apply in the Louisiana court,
So
if it was applied all.
The success that was achieved was he was not required to deposit the disputed funds in the registry of the Texas court, which was being asked of him. And the judge denied that motion. Judge Shadwick denied that motion on the record, and he said, given that the assertions by counsel that the two proceedings are different, I'm not concerned. You can use this transcript if it ever comes up. And so he denied the motion.
I thought Judge Shadwick said the money's was already deposited in the Louisiana court, and that's why since it was already deposited over there. Am I misremembering that?
No, you're correct. It was deposited there, so the argument was the issue was moot. But he also said on the record, and the Court of Appeals picked up on this, was that there was a statement by Ammons' counsel that the proceedings were different and the barratry claim was here and the fee claim was over there. So what would happen over there would have no impact on what would happen over here.
So if that were the case, I would think that if you're relying on the Fleming line of reasoning, that the answer would have been when the Louisiana court decided nonetheless to address this, to say, wait, you can't, that's judicial estoppel. They made this representation and prevailed in the Texas court. And then if the Louisiana court nonetheless barreled forward, then you'd bring an appeal in the Louisiana system. But instead, that became a final judgment as far as I know.
It became a judgment with regard to the claims that were being asserted over there.
So do we get to sort of sit in judgment of that, though, collaterally here? I mean, what we have is something that seems on its face to tell us what we need to know about whether it was impermissible in Louisiana.
Chief Justice. So I think you can get around Ammons' argument in several different ways. One is judicial admission, which was not an issue in Fleming. One is waiver because he consented to claim splitting, and this court has held that if a malpractice claim is severed from a fee claim, the fee claim cannot be used as res judicata on the malpractice claim. And so we argued several reasons why Mr. Ammons was stopped, or he waived it, or he judicially admitted it, and the Court of Appeals kind of blended the concepts, but ultimately came to that conclusion.
And I apologize, Chief, but I don't think we gave you a chance to talk much about limitations, and if you have a very brief point you want to make on that.
I do. I think that this court hit it right on the head about the statute being unique, and it has, it's not recognized in tort. It's not a tort remedy. It's a statutory claim. It's created by operation of law with a contract component in it. It's similar to what this court decided in the breach of warranty cases that Justice Busby was talking about, that it's a unique claim. You have to look to what it's like. And I think that Your Honor picked up on it being, maybe it's like a fraud claim. Well, I think even more analogous is maybe it's a breach of fiduciary duty claim, because the claim does not arise absent a contract. And once a contract between an attorney and client is entered into, fiduciary duties arise, and it has a remedy of disgorgement, which is unique to a breach of fiduciary duty claim. And so if the court is looking to analogous tort claims, look to that sort of claim, which has a statute of limitations of 4 years. The last thing I'll say with regard to limitations, something that my colleague did not address, is that we would ask this court to apply the discovery rule to those claims, whether under subsection A or subsection B. This court held in Willis v. Maverick that a client in a legal malpractice claim lacks the legal acumen to understand that they have been wrongfully injured by their lawyer when the injury occurs.
But here, the injury is being solicited. They don't lack the acumen to know that.
True, but solicitation alone is not enough. It has to be solicited by conduct violating the laws and rules governing barratry. So necessarily a client must understand, okay, does that solicitation violate the laws and rules governing barratry? Because not all solicitation is unlawful. You have to have an intent to obtain an economic benefit for it to be a violation of the penal code. Some solicitation is allowed if it's for nonprofits or you're doing it for without a fee. And so the client doesn't know that. All they know is that they've been solicited.
Surely they're on inquiry notice of those questions, at least, because they were solicited.
But oftentimes they're solicited and they hire the lawyer, and then the lawyer doesn't tell them anything. And so they go on down the road for more than 4 years with this lawsuit, and then by that time the statute of limitations has lapsed on any solicitation claim because the lawyer's been representing them for 4 years.
I don't want to belabor it because I know the time is up, but
Yeah.
it seems to me in reading your arguments that we would upend a lot of our limitations case law if we were to adopt this approach, because there's a lot of complicated law where people don't know all of the predicate facts, that which is underlying, and nonetheless we say, well, you had everything you need to know to investigate. And it's on the books. There is these claims that we're talking about. We know what you need to know in order to do it. So I'm afraid that if we were to follow your path, we would be basically saying that limitations is almost never really what it seems to be. And I'd appreciate just a very, very brief response to that.
I understand the concern, but I think this case is different because, like counsel said, solicitation is not unlawful in many states. And so a lot of times victims of it don't recognize that they are suffering a legal injury caused by the wrongful act of another when it occurs.
Any other questions? Thank you, counsel.
Thank you.
Mr. Gagey, I believe you have 5 minutes.
Was the financing of solicitation in Texas unlawful by itself? Whether or not wherever the solicitation might take place, was financing improper solicitation unlawful?
Your Honor, I'm glad you asked me that question, and I'd call your attention to the statutory text to talk through that issue on tab N. The financing is unlawful for criminal prosecution purposes, but we're not here discussing the criminal prosecution purposes. What we're here discussing is the civil barratry statute. And so, for example, look at 38.12A sub 4. You could be prosecuted for a crime for paying or offering to pay, anything to just solicit employment, which is, you pay for access. You could be prosecuted for that, but unless you actually follow through and directly solicit, you don't have a cause of action under the civil statute. And the way I know that is based on the statutory text of 82.0651. So if you flip back to tab K, which is 82.0651, subsection A has the words procured as a result of conduct. You cannot procure a contract unless you actually engage in the act of solicitation. For example, let's say someone sets up an enterprise to solicit someone out of state. They knowingly finance, but they never actually follow through on the act. Maybe there's criminal liability, maybe there's liability under the disciplinary rules, but there would not be any liability under the civil statute because there was no procurement. And that comports with traditional standing principles that require an injury that is directly traceable to some conduct. And that's why we say the focus of this civil barratry statute is not the knowing financing component, it's the direct solicitation component. And therefore, necessarily, what we're doing when we look at direct solicitations that happen out of state is we're extending Texas law out of state. And that's why, in response to your question to opposing counsel, you cannot sidestep the presumption analysis in this case. Now, I want to say a few quick words about the Goldstein decision, because the Goldstein decision really undercuts a majority of the other side's argument. What the presumption requires is a clear indication, either based on text or purpose or history. And they mostly focused on Texas Penal Code 1.04, but this court has clearly said that that has nothing to do with civil causes of action. And so all they can rely on is the purpose provision, but the purpose provision is not a clear indication that the presumption against extraterritoriality has been rebutted. There was a repeated mention of the Citizens Insurance versus DACA case, and I'd like to give the court a roadmap to distinguish that case because I think it's very different. First of all, that case, the explicit focus is on registration in the state of Texas as a securities dealer. And the reason for that is because it's part of a model act, it's a Blue Sky Act, and universally throughout the United States, these Blue Sky Acts, or at least that's what Citizens Insurance tells us, are understood to apply where there have been sales from a home state even to non-residents. But that's not the case here. Texas is the only state with a civil action for barratry, and so you cannot apply the Citizens Insurance logic here. Finally, I want to make two quick points about the limitations analysis. There was a suggestion that there should be an analogy to breach of fiduciary duty. But keep in mind that a lawyer may improperly solicit a client, get attorney-client engagement, and then maybe perform perfectly, get the exact result the client wants, and they could still sue under the statute. In other words, a breach of fiduciary duty claim requires some kind of breach of a duty. Just like a legal malpractice claim requires some breach of prudence or skill that's usually required of a lawyer. This statute doesn't require that, and that's why analogy to either breach of fiduciary duty or fraud would be improper.
If we used your idea of analogy, wouldn't, if we agreed with you that the 2-year statute applied, wouldn't we apply use tolling as well?
Well, Your Honor, use tolling requires that there be malpractice in the prosecution or defense of a claim. And there are 2 points here. First, there's not a malpractice claim because you don't need to violate your prudence or skill as a lawyer to be sued under the statute.
Right, but if your lawyer is representing you and the lawyer's committed barratry, doesn't it make sense that that claim, limitations wouldn't begin to accrue at least until the lawyer completes the representation?
No, Your Honor, because this court, as recently as the Levinson case just 2 years ago, said do not expand the use tolling rule beyond its articulated paradigm. And this is not the articulated paradigm. And let me give you an example for why not. Even a transactional lawyer could get sued under the statute because they improperly solicited work. But transactional work would not be in the defense or prosecution of a claim, and you've told us that use is a categorical rule. And so you can't have a situation where use applies to some kinds of 82.0651 claims, but doesn't apply to others.
Any other questions? Thank you, counsel.
Thank you.
Case is submitted and the court will take a brief recess.
All rise.